There we go.
Oh, thank you. Oh, thank you. I'd been muted. Right, the committee manager, David Pope, has given the procedure that will take place this afternoon, and it is now being on YouTube. And thank you for your patience with a few glitches. Right, I'll now start with the agenda. Are there any apologies, Callum?
Thank you, Chair. There's no apologies today.
Thank you. There are no urgent items. Do any of the committee members have any declarations of interest? I have none. Councillor Mitchell, any declarations of interest? No. Councillor Bundy?
No, Chair.
Right, thank you. Right, we will now consider an application for review of the premises licence for the Red Rose Restaurant, George Street, Kettering. I'm going to ask the Health Manager, Russ Howe, to give the report, and then I shall ask the Chief Immigration Officer, Jack Davis, also to give his report. But we'll start with Mr. Howe. Thank you, Mr. Howe.
Thank you, Chair. As you say, we're here this afternoon to consider an application for review made by the Immigration Enforcement Team at the Home Office with regards to the premises licence and the Licensing Act 2003 for the Red Rose Restaurant in George Street, Kettering. A copy of their application is in the papers. A copy of the premises licence that was in effect at the time of that application is also in the papers. Since that time, a transfer application has been made on the premises licence, which has basically just removed one of the previous licensees, and Mr. Mothin Mia, from the licence. Other than that, the licence is exactly the same. As we do with all of our applications, the application has been out for consultation for the 28 days as required by the Licensing Act 2003, and no other representations against this licence have been received. The review application relates to a visit to the Red Rose Restaurant by Immigration Enforcement at the end of October 2019. Obviously apologise for the delay in getting this matter before the committee. We've had the issue of lockdown, and then when the matter was supposed to be before committee 3 weeks ago, we had some IT issues which resulted in some information not getting through in time, so the matter is adjourned today. So with regards to that visit by immigration in October, at that visit they found a number of the employees at the premises had no right to be working in the country at this time, and also an employee who may also have given a false identity, who managed to leave the premises before anything further could be done with him. Only the manager on site at that time had a right to work in the UK. We've had additional information provided by Mr. Fender on behalf of the licensee, which is included in the packet Appendix C, which is, as I understand it, right to work information for the current employees. I'm sure Mr. Fender will clarify that for the committee in due course. We've also now got the information from the Immigration Enforcement Team, including the papers.
Sorry, we might need to bear with me a second, because Mr. Fender has disappeared.
Oh, yes.
And obviously he's going to need to hear the whole report. I'm not quite sure where Mr. Fender has gone.
I was in full flow then too.
I know. I'm just going to wait to see if he comes back. There's not really anything I can do except wait for him to return. I'll drop him an email while we're waiting to find out where he's gone to. Aha. Bringing him back in now.
Yeah.
Mr. Fender, can you hear us? You're muted, sir. Mr. Fender, you're muted. There we go.
My internet connection dropped out, so I do apologise. That's what happens when you have workmen in the road and you work from home.
We'll pick up from where we've left off.
I was at the point where Mr. Howe was reading through his report.
Yep, we stopped when we noticed you disappeared.
Oh, sorry.
Where we've left off.
Thank you. I do apologise.
Right.
How far had I got, Frank?
Carry on.
Sorry, thanks, Russ.
How far had I got?
You were just going on to the application was attached at Appendix A, and then I started having tricks. Paragraph 2.1.
We'll start again then.
Yeah, I thought you might. Sorry.
That's okay. So you got the application attached to Appendix A. At Appendix B, you have a copy of the premises license as was in effect at the time of the visit to the premises. That premises license has been subject to transfer since that time, but the only effect it had on the license was to remove the name Mothin Mia. Otherwise, it's exactly the same premises license. The application has been out to consultation, as we always do, for 28 days, and no other representations have been received with regards to the license or the application. The application relates to an immigration enforcement visit to the Red Rose restaurant on the 31st of October 2019. At that time, immigration found a number of employees on site who had no right to work in the UK. 5, I think they found, and 1 disappeared during the evening. Only the manager on site at the time had a right to work in the UK at that time. Mr. Fender has submitted a pack of information with regards to what I believe is the current establishment at the premises, staff establishment at the premises, and their right to work information for the committee, and I'm sure he'll be discussing that when he gets the opportunity to speak himself. As I said earlier, there was a pack of information submitted by immigration enforcement which was quarantined by our IT system just prior to the last proposed committee hearing. That information is now before everybody. It's quite a substantial pack of information, witness statements from the officers that attended that evening, together with a summary report from immigration, which, having looked at it, I think adequately summarises the guidance and case law that applies in this particular circumstance. I don't need to refer to the guidance that I've picked out for in my report. I will also refer the committee to our statement of licensing policy, as I always would. And finally, just to remind the committee that any decision they make may be subject to appeal by any party involved in this hearing. That's the report, Chair.
Right, thank you, Mr. Howe. Right, could I ask the Chief Immigration Officer, Jack Davis, now to give his verbal report? Thank you.
Yes, thank you, Chair. I think there's very little more that I can add to what's already been said. If the councillors have all read the package details from the Home Office, then I think it quite adequately outlines the circumstances of what happened on the 31st of October last year. And it details clearly that 5 employees on site were found to have no right to work. One person disappeared during the course of the evening. Now, the only person who was present who was able to work was Mr. Sonor Ali, who was persistently uncooperative and disruptive through the course of the interviewing and the arrest of the people who were detained. I'd just like to highlight a couple of points there in particular that are drawn out in some of the statements, that several of the members of staff explained that they are being paid cash in hand, which I can only assume to mean, given that only 2 members of staff were declared to HMRC records, that they were off the books. They had no contract. Some of them had not even seen their employer. The accommodation was linked to the provision of work and labour. And 2 different pay rates were being quoted, one at £100 per week and one at £50 to £60 per week plus accommodation. Well, some might say that smacks very clearly of all the indicators of modern day slavery and the concerns that can be associated with that. Without going too much further into the details, as the pack's been fully read and does set out quite clearly what happened, I can only suggest that in this situation, no amount of mitigation can be offered to suggest that it's appropriate to impose additional conditions that might alleviate the situation happening again. I'm slightly concerned to see that amongst the large number of staff who are now being listed as employed there, we still have Mr. Sonor Ali, who was the cause of problems on the night in question. And it does beg the question, if so many members of staff are needed now, and 5 or 6 were encountered on that night, why were only 2 being declared to HMRC? It might be the case that an entire change of management and licensing has taken place. If that were the case, then I think that we might not be in a position where we're looking to request the revocation of the licence. But I don't think that that's the case that's in hand here at the moment. If there's any questions that I can answer to try and assist, then I'm happy to do so, but I don't see the point in taking too much more of your valuable time or risking any further difficulties with the internet that we've all suffered today.
Right, thank you, Mr. Davis. Are there any questions from the councillors for Mr. Davis? Councillor Bundy, any questions? Any questions, Councillor Mitchell? No. Right, thank you, Mr. Davis. Right, now ask then Mr. Fender, Mr. Frank Fender,
Yep.
and Mr. Manwar Rashid. Who's going to go first? Mr. Fender?
Yes, I shall speak on behalf of Mr. Rashid, Councillor.
Right, okay, thank you, Mr. Fender. Right,
Thank you.
I'd like to speak now, thank you.
Yes, as you've heard, Manwar Rashid is present. He is one of the 2 premises licence holders for these premises. The one that was removed is Mr. Rashid's brother, who no longer has any connection with the business. The other licence holder is the father of Manwar. He's been poorly, so there's likely to be further changes in terms of moving forwards. I'd like to start off on behalf of Mr. Rashid by apologising for today, apologising for the situation they find themselves in. It wasn't an intentional thing, and they know they've got to get things right at this restaurant. Before I go into some of the circumstances, I'd like to remind members that the purpose of a review hearing is for the licensing subcommittee to establish whether or not licensing objectives are being promoted at these premises, and if not, what measures or sanctions are appropriate to ensure that the licensing objectives are promoted when moving forwards. The purpose of the review hearing is not to determine guilt or otherwise. The determining of guilt or otherwise is a matter for the courts of law, not a matter for the licensing subcommittee. The purpose of the review is not for you to impose punishment. That is also a matter for the courts. As I've already stated, the review is to establish the promotion of the licensing objectives. The Red Rose restaurant has been licensed to sell alcohol for many years. The current license holder, Koisha, he actually started this business back in 1991, nearly 30 years ago. Manwar Rashid has been associated with the premises for the past 10 years. You've already heard also that the premises has a manager, Mr. Sonor Ali. He is mentioned in the review application, and I will comment on that in a few moments. The premises are a long-established family-run business. They've built up a very good reputation in Kettering, and for all of those 30 years, they've never been a cause of concern for any of the authorities. No issues for the police, no issues for the licensing authority, no issues for any of the other responsible authorities. That in itself is an excellent track record of managing a licensed premises, licensed to sell alcohol for nearly 30 years without issues. That can be evidenced in the fact that there are no other representations supporting this review application today. If any of the other authorities had any concerns about these premises, they could have made representations in their own right. The application for review was made as a result of the immigration visit at the end of October 2019, and it is alleged that at the time of that visit, the Immigration Service discovered 5 people who were not entitled to work in the UK. That information is provided on page 10 of your report, submitted as part of the initial review application. That same information on the same page suggests that a 6th person escaped. It's a suggestion that he possibly gave a false identity, but there's no evidence to support this claim. It's a suggestion. The evidence produced by the Immigration Service goes on to say that the only person encountered during that visit who was entitled to work in the UK was Mr. Sonor Ali. The Immigration Service state, not only in the application, but Mr. Davis has referenced this as well this afternoon, that he was totally uncooperative and refused to provide information to immigration officers when asked. I have been advised by Mr. Ali that he is not a person who refuses to cooperate, but that his actions on that evening were dictated by the actions of the immigration officers, who, he tells me, were oppressive, forceful, and very demanding. If you imagine 8 immigration officers entering a small restaurant, rounding people up like sheep and being very forceful in their directions to these people, is there any wonder that the behaviour of Mr. Ali was met? He didn't really want to answer questions, he wasn't sure what was going on. You can't really expect him to be subservient and answer all questions to the satisfaction when that sort of thing happens. Following the visit, information was requested by immigration officers about those at the restaurant. That information was requested by immigration with a view to issuing a civil penalty notice. That information was provided. That is cooperation. The premises license holder accepted that 5 persons were at the restaurant when the visit took place, although he doesn't accept that they were all actually working at the premises, nor were they under a contract to work. That information was conveyed back to immigration when they objected to the civil penalty notice, but the Immigration Service did not accept the account of the premises license holder, and they issued a civil penalty notice in the sum of £50,000. Yes, that's a lot of money, but it started at £75,000. It was reduced to £50,000 because of the cooperation from the premises with the Immigration Service in providing the additional information requested. This shows a willingness to cooperate that was recognised by the Home Office. The premises licence holder is not looking to avoid liability for what has happened. He accepts that he got things wrong, especially in that he did not maintain records showing that staff had a right to work in the UK. He accepts that he should have maintained records, and that as a result of that failing, he has to accept the punishment of the civil penalty notice. Arrangements for the payment of the civil penalty notice were being negotiated throughout March this year, but obviously the coronavirus pandemic put a stop to those negotiations. The subsequent lockdown measures have effectively put those arrangements on hold, and therefore there's been no other email exchange at the moment. But that will be sorted out and corrected once the sense of normality returns to life in this country. Since the visit and since the issue of the civil penalty notice, Mr. Rashid took advice, and he has put things in place to ensure that he does not make the same mistakes again. He has not sat back and done nothing. He knows he needs to get things right. Mr. Rashid has now made sure that his staff employment records are up to date and accurate. He makes sure that appropriate due diligence sheets are maintained and that any subsequent checks that need to be made in the future are diarised. Copies of those records, which are now maintained at the premises, were sent and referred to in your report. They were referred to by Mr. Howell. These right to work check sheets are maintained at the premises. They can be examined on request. Any subsequent staff who may be employed at the premises following the easing of lockdown will themselves be the subject of the right to work checklists, and copies will be retained at the premises. I should also point out that following the immigration visit of the 31st of October, the premises were visited by the fire service and a council housing officer. Apparently, those services were requested to visit the premises by the immigration service. The fire service and the council officers expressed no concerns to Mr. Rashid as a result of their visit. They did recommend that smoke and heat detectors were installed on the first floor of the premises. This has been carried out. Neither of those two authorities have made any representations to this review application. They could easily have done so if they had any concerns. Mr. Rashid is a man who takes his responsibilities seriously. He is not a person who deliberately flouts the law. He has a young family to support, and that he knows that if he does not do things properly, then the loss of a premises license will have a damaging effect not only on the business, but also on his family. He's not sat back and done nothing. He has taken proactive steps to get things right. He intends to maintain this level of responsibility at all times. The Immigration Service supplied additional information as referred to by Mr. Howell. That additional information isn't paginated, there's no page numbers, but in essence, it provides information as to case law, the reason for the review, and other pieces of information as well. They also tell you what they desire from today's proceedings. Their default position is for the premises license to be revoked. The Immigration Service then provide information to provide you with details of case law submitted, no doubt, to influence your decision today, and to provide you with reasons why you can justify revoking the premises license at the Red Rose restaurant. I do not propose to go into the ins and outs of case law, but I would remind you that all decisions on review applications, and indeed any other licensing applications, must be decided upon their own merits. That's even mentioned in your own statement of licensing policy at paragraph 2.13, which states, in determining a license application, the overriding principle adopted by the licensing authority will be that each application will be determined on its own merits. The Immigration Service are inviting you to revoke the premises license today because it's happened in other areas of the country. And then, of course, they draw similarities or try to draw similarities between the case law and this case today. The Immigration Service also provides you with case law to show that you can punish the premises license holder today by revoking the premises license. I would remind you that a review hearing seeks to establish whether the objectives are being promoted, and if not, what steps can you put in place to ensure that they are. Whilst decisions may have taken place in other cases, in other areas and other dates, your decision today must be based on the individual merits of this application today, not based on what may have happened elsewhere. You will also note in the Immigration Service papers that they have tried to preempt any counter argument or defence that the premises licence holder may try to bring to these proceedings. They then tell you why such counter arguments and defences should not be listened to. They tell you why the addition of conditions to a licence is simply insufficient. The Immigration Service state, and I quote, "In seeking revocation, Home Office Immigration Service has considered and rejected conditions as an alternative, in part because, as stated in the Section 182 guidance, conditions should not duplicate other statutory requirements." Now, we take issue with that claim that conditions being appended to a licence are insufficient, or indeed that they are just a duplication of law. Any conditions on a premises licence carry severe consequences if they are not complied with. A maximum penalty of an unlimited fine 6 months imprisonment, or both. That has the effect of focusing the mind of any premises licence holder. If I can draw you back to your officer's report, on page 4 of that report, Mr. Howe provides you with some of the relevant paragraphs from the section 182 guidance. For example, paragraph 11.19, it provides you with the sanctions that you are available to consider today. Paragraph 11.27 of the guidance provides a list of offences which should be, according to the guidance, treated particularly seriously. That list includes the right to work. Paragraph 11.28 of the guidance states that revocation of the premises licence, even in the first instance, should be seriously considered. But there's another paragraph in that guidance which is also relevant, but it's not included in your officer's report, and that's at paragraph 11.20, the paragraph that immediately follows the paragraph which outlines the sanctions available to you today. I would like to draw your particular attention to that paragraph, 11.20, which states, and I quote, "In deciding which of these powers to invoke, it is expected that licensing authorities should, so far as possible, seek to establish the cause or causes of the concerns that the representations identify. The remedial action taken should generally be directed at these causes and should always be no more than an appropriate and proportionate response to address the causes of concern that instigated the review." I ask you to pay particular attention to that paragraph in the guidance. Sanctions imposed should always be no more than an appropriate and proportionate response to address the causes of concern that instigated the review. We therefore respectfully submit that the most appropriate and proportionate sanctions in this case are to modify the conditions of the premises licence. The Home Office papers state that conditions are insufficient, but this comment seems to contradict paragraph 2.6 of the statutory guidance issued under section 182. That paragraph is also included on page 4 of your council report. And that paragraph states, and I quote, "The prevention of crime includes the prevention of immigration crime, including the prevention of illegal working in licensed premises. Licensing authorities should work with Home Office immigration enforcement as well as the police in respect of these matters. License conditions that are considered appropriate for the prevention of illegal working in licensed premises might include requiring a premises license to undertake right to work checks on all staff employed at the licensed premises, or requiring that a copy of any document checked as part of a right to work check are retained at the licensed premises." So the guidance also states that conditions could be appropriate in respect of right to work issues. We would therefore propose the following conditions to be added to the premises licence. Conditions which are appropriate to ensure the promotion of the licensing objectives. Before I go through the 4 conditions that I want to propose, I will also add a small explanation at the end of each to explain why those conditions are not, as claimed by the Immigration Service, a duplication of law. The first condition that I would like to propose, Chair, is that the premises licence holder will operate a full human resources management system where all relevant documents to prove entitlement to work are stored for each individual member of staff. This is not a duplication of law, Chair. It is over and above what is required. There is no actual legal duty to force any employer to carry out right to work checks. It's not a legal duty. It's advised by the Home Office, it's advised by the Immigration Service, and what they do say that is by carrying out such right to work checks, you can give yourself a statutory excuse if it then turned out that those people did not have a right. But there's no offence in law to have to carry out those checks. By conditioning the premises licence to force the employer to carry out those right to work checks, that is not a duplication of law. The second condition I would like to propose: all copies of relevant documents for members of staff will be retained for a period of 24 months post termination of employment and will be made available to police, immigration or licensing officers upon request. Again, not a legal requirement to maintain those records at the premises. If you condition the premises license, then it becomes compulsory. The license holder must do this, otherwise face the consequences. The third condition that I would like to propose is that the premises license holder will work with an immigration compliance business to carry out checks on the Home Office website and to verify identification documents such as right to work documents to ensure that all new members of staff can be legally employed. Again, Chair, over and above any requirements, this will ensure that all checks have been carried out properly, leaving no room for error. And the fourth condition: no new member of staff will be able to work at the premises unless they have provided satisfactory proof of identification and right to work. And this includes any work undertaken on a trial period or a part-time basis. All too often, we hear that we didn't do right to work documents because they were on a trial. This condition prevents that from being able to happen. On a trial, even for an hour, right to work check records will be compulsory because they will be a condition on the license. The imposition of these conditions, or the implementation of these conditions, will ensure that the measures that he has already taken are continued throughout the life of the business. There is no room for complacency, because if they don't comply with those conditions, they have serious consequences in their own right. It is our submission that the imposition of these proposed conditions is an appropriate and proportionate response to the reasons for the review application. The conditions proposed address the causes of concern that instigated the review application. Chair, for those reasons, I would ask you not to revoke the premises licence today, but to add the conditions as proposed, which forces the premises licence holder to carry out the required checks, to carry them out properly, and therefore promote the licensing objectives. Thank you.
Right. Right. Thank you, Mr. Fender, for that. Are there any questions?
Sorry, Chair, could I just come back in?
Yes, of course.
I just feel that it might be nice for you to hear from Mr. Rashid through his own words as well before we get to the question stage. I do apologise.
Right,
I did mean to bring him in.
Mr. Rashid? Right, your turn to speak, Mr. Rashid.
Can everyone hear me?
Yes.
Yep.
Okay, yeah. Well, I am very sorry for what has happened, and we have put systems in place, and I have begun doing everything accordingly, so we do not make this mistake again. It doesn't happen again. You've got the evidence there. I am doing the checks now with the new employees that I have employed, and I shall intend to stay on top of this. So in regards to the license, I would request that it is not revoked or cancelled. If there's any way of going about this without cancelling it, and maybe the conditions, I would be grateful. Thank you.
All right, thank you, Mr. Rashid. Right, Councillor Bundy, do you have some questions for Mr. Fender?
Quite a few, actually, Chair. First of all, can I ask, why has Mr. Koisha Rashid resigned as director of the company? And he was designated premises supervisor. So who is designated premises supervisor now? I'd also like a little bit more clarification on why HMRC only had 2 employees who were registered as employees of the organisation. That strikes me as very, very strange. We're told that the holding company started trading in June 2019, but Mr. Fender told us that that the company's been in existence since 1991, and we know that Mr. Manwar Rashid was license holder since 2006. Who were license holders before that? Who actually has the day-to-day control on the organisation? Was it Mr. Koisha Rashid, or was it Mr. Ali? There seems to be a little bit of a grey area there. Shall I stop there and you can address those first, Mr. Fender?
Yeah, I think Mr. Rashid, can you answer the councillor in respect of the current makeup at the premises? Who's overall responsible for employment of staff, for example? Who's overall responsible for the management of the premises?
Right. I am responsible for overall operation of the business, and as it's been a family business, we've actually all been doing a bit of everything with my father, myself. Recently, more so myself because Dad's not been too great. We've always been the license holders, even though on the limited companies, you referring back, you say, yeah, we've been trading since 2019. The premise, we as a premises license holder, we've been trading under the name of Red Rose, but obviously their company that we've been trading under has gone a few changes in the past when the ownerships changed, because prior to when the license was obtained in 1991, my father Koisha Rashid and there was another Mr. Ali on the license holder, and back in 2008 it might have been when Mr. Ali left the business. That's when I came onto the license. I was added on, and my brother was added on as well. And at no point there has been 2 employees. So I don't know how we've obtained the HMRC information, but at no point there would have been just only 2 employees. That would be impossible to run a business on just 2 employees. So I am not sure how the accuracy of that.
Can I come back, Chair?
Yes, of course.
Paragraph 1.5 of the Home Office, Immigration Officer's report says staff records held by HMRC show only 2 employees. So that's where that's come from. So why has Mr. Manwar Rashid been removed from the directorship of the business? And also, sorry, before finish, you also said Mr. Ali has left the business. I thought Mr. Ali was there when the immigration officers entered the premises in October.
Okay, now this was a different Mr. Ali. So back in 1991, if you look at, I don't know if you've got access to the history of the license, my father and Mr. M. Ali was license holders. And when Mr. M. Ali left the business, it was myself, Manwar Rashid, and Motin Mia, who was added onto the license. And now referring to the HMRC, there's been 2 companies. Okay, So I think you'll refer, since June 2019, we've been trading under Masala Limited. So Masala Limited, trading as the Red Rose. You will find I am the director on there. Prior to that, it would have been Yasin and Aisha Limited. So it's had a few limited companies, but it's always been trading under the same ownership, same family.
Can I also add in there for you, for Councillor Bunday, through you, Chair? 1991, of course, premises licences didn't exist. All the licences were issued by the Magistrates Court in those days, and the premises licences were only introduced with effect from November 2005. Premises licences can be in the name of individuals or companies. If they're in the name of individuals, there's nothing to stop premises being managed or trading under company names. The premises license holder is what's important for the Licensing Act of 2005, as opposed to the company trading name.
You still haven't explained why Manwar Rashid has now been removed from the company.
No, I am still on the company. I have not been removed.
No.
Masala Limited is the company.
Oh, sorry. I meant Mothin.
Mothin has been removed from the license. He was never involved with the company.
Right.
He was simply a family member who, at certain points, he helped us out with the business, and since then, for a good few years now, he's not been involved with the business, which is why I thought it was only fair to remove Mothin from the license.
So who's DPS now?
DPS is still my father, Koisha Rashid.
Right, any further questions, Councillor Bundy?
I have, but I'll come in later. I'll let Councillor
Mitchell. Yes, okay. Councillor Mitchell, have you got any questions for Mr. Rashid or Mr. Fender?
Yeah. On the night, Mr. Ali was the DPS, wasn't he, on the night in question?
No.
Happened. No.
No. The immigration papers suggest that there were two DPSs. The law actually only allows for one.
Hmm.
Yeah.
So where that information came from, we're not sure.
Was there a license holder on site on the evening?
I think
a personal license holder or a designated premise. Was there anybody there who had a license to serve alcohol?
Well, there's no requirement in law for there to be a personal license holder on premises whenever alcohol is sold. So long as those that are at the premises selling alcohol have permission to do so from a premises license holder.
Can I add something to this?
Yes.
Yeah, Mr. Ali, Sonu Ali is actually a personal license holder.
Right.
Right.
And I also hold a personal license, but on the evening in question, Mr. Ali is the personal license holder.
Right. Lloyd, do you want to come? Because I've got other questions. I'm just trying to word them in my head, but Lloyd, if you want to come back.
Right. Okay. Councillor Bundy.
Yeah, I'd like a little bit of clarification. The residents above the Red Rose or adjacent to the first floor, if they weren't there to work, why were they there?
Can you answer that, Manuel?
Sorry, could you repeat that for me again?
If the residents living over the Red Rose weren't there to work, why were they there?
Oh, the people that are in question, the ones that they were working. Not all of them. So out of the 5 people, they were not all working, and few of the persons were just given accommodation because they were homeless. And I have stated that with the Home Office in that they were just given basically food and living accommodation to stay there. But yes, with the accommodation, that is part of the job.
So are you saying then that you benevolently give accommodation to homeless people as long as they wear a uniform?
Sorry, there was not. I don't believe
Well,
they were. I mean, I
all
was not in the evening. I don't believe they were wearing any uniform.
All the immigration officers' interviews talk about the fact that the staff were there wearing uniforms.
Right. I mean, I was not there at the evening, so I suppose I just have to go by the information on the Home Office's statement.
So, Mr. Rashid, you accept that you got things wrong.
Yeah.
The Home Office or the immigration officers interviewed a lot of people who basically said that they weren't asked whether or not they had the right to work or not. Did you know that you were getting things wrong?
No, I was not aware. This is what I'm saying. I've got things wrong. I wasn't making the necessary checks when employing the ones that were employed. I wasn't making checks on anyone. So, which is what I have began doing now. I'm doing the proper checks.
So, you've been a licensee for over 30 years, Mr. Rashid, and you're telling me that now
he hasn't been a licensee for 30 years, Councillor.
So
the business has been up and running for nearly 30 years. I think Mr. Rashid's involvement was in the last 10.
Okay, so for 10 years, which is probably more when the immigration rules and everything else came in. I just wonder whether or not we're in a situation where we're shutting the door after the horse has bolted, and the changes that you're now saying that you're making purely and simply because you've been caught.
Well, I have realized I have made some mistakes, and it has been pointed out to me before. I mean, it's basically, it has been a wake-up call. Before that, you know, it's something I didn't really think about doing. But yes, I mean, it has been a wake-up call, and it is something I intend to stay on top of.
You see, I would say, and Mr. Fender pointed us to 1.2 of our licensing policy, about cause and concerns, and one of the things we have at our disposal is to actually remove personal license holders from premises, to actually remove the DPS from the premises. But I do wonder whether in this situation that would be a proportionate thing to do, because all we're doing is actually saying, right, the person who owns the premises should be removed as DPS, and if you remove that function from that owner, they're still the owner, so they are ultimately still in control of those premises. So I'm just struggling to find what recourse we have.
Can I add that the removal of a DPS is actually quite effective, because whilst you might believe that the management of the premises still stays within the same structure, it adds an extra tier of responsibility. So you basically, instead of one person taking overall responsibility for getting things right, that responsibility falls on more than one pair of shoulders. And therefore, if they're both on the outside looking in and they're both getting things done, it ensures that they get things done right. So that it can be effective, Councillor.
It depends whether the root cause in the first place are the owners of the premises.
That can be. I've come into contact with many people that have been in this position before, and I just want to address your comment in respect of, is this after the horse has bolted, so to speak? And I would agree, it is after the horse is bolted, and that's even referenced in the immigration papers in their pack, that people only seem to do what they have to do once they've been caught. But it's my experience, and I speak with many years of experience in this, that whilst people know that they should check people's right to work, they don't maintain records. They don't maintain it. And that's why they don't have a statutory excuse, because they haven't maintained those records. If I can just give you an example, I deliver personal license training courses, or at least I used to until lockdown. And the right to work checks is not even part of the personal license training course for license holders, for proposed designated premises supervisors. I think that's a flaw. I add that into every single course I do to try to avoid situations like we find ourselves in this afternoon.
Right, thank you, Mr. Fender. Can I ask if our legal advisor has got any questions? No?
No, no questions.
Right, nothing at the present. Right, thank you. Councillor Bundy, do you have any further questions for Mr. Rashid or Mr. Fender?
Just an observation that if the premises had been a situation where the immigration officers had arrived and found one person who was illegally working there and 5 or 6 people who were legitimately working there, I think we'd have been in a better place than where we are today, where immigration officers turned up at the premises and found one person legally working there and 5 or 6 who were illegal.
Mm-hmm. Right, thank you. Councillor Mitchell, any further questions? Right, thank you. Right, thank you, Mr. Rashid and Mr. Fender. Right, now then, can I ask Councillor Bundy and Councillor Mitchell, shall we give the decision notice in writing within 5 working days?
I think that would be a good idea, Chair. I think we've got a lot to discuss.
Yes. Councillor Mitchell, you agree that
Got a
it
lot
would
to
be given?
discuss, so it wouldn't be. I don't think it'd be fair to keep them hanging on. So I'd say 5 days.
Right, okay, thank you. Mr. Howe, is there anything further you wish to add, or from the Chief Immigration Officer, from Mr. Davis? No?
No, Chair, thank you very much. I think everything's been summarised quite neatly, and already some of the points have been picked out. I'll leave you to make an appropriate decision and wait for it in due course. Thank you very much for your time.
Right, so thank you, Mr. Davis. Right, so I'll say thank you very much to our Health Services Manager, and thank you very much, Mr. Fender and Mr. Rashid.
Thank you very much, Chair.
And
Thank you,
the
Councillors.
committee will now have a discussion. Right, okay, then Committee Manager.
Thank you very much, Chair. I shall end the stream on YouTube now.